All right, we are officially on the air. Let's see here. We've got another minute or so before we're officially supposed to start at 1 o'clock. So we've got a few folks joining us right now. My name is Bryce Ballou with Tradecraft Industries, and we have January Allen with us from Cotney Construction Law. And so Tradecraft Industries is a co-working space and incubator space for primarily the construction industry, but we service any and all small businesses that are looking to grow. And as part of that, and part of these times, we're trying to adapt a little bit and still provide some of the value adds that our members need in order to grow their businesses in very uncertain times. And so Cotney Construction Law has been a great partner for us. We've actually done a few other webinars and lunch and learns with them. And there is a lot of changing things going on with legislation, with COVID, that not only employers, small businesses, everybody needs to know. So rather than really getting into the fear-based, we're going to be really focusing on fact-based and looking at this as an opportunity for businesses to really take a double check of where they are, where their contracts are, where their employees are, where their business is. Because that's what you can really affect and control right about now. You can't really control much else, it doesn't seem like. So January, I'll turn it over to you. Thank you so much for your time, and tell us a little bit about yourself and what we're going to be learning today.
Thank you, Bryce. We also appreciate all the support with Tradecraft and the great partnership. I'm excited to be talking with everybody this afternoon about some of the employment law changes that we're seeing with COVID-19. And I'd first like to begin by thanking my law partner, Ben Briggs. He's in our Tampa office, for his efforts in digesting these laws so quickly and putting together the bones of the presentation for us today. So many employers and employees out there right now have a lot of questions that are unique to their situation. So for a couple of reasons, I'd like to ask that specific questions be either emailed in or we can handle them on a later phone call. The presentation's for educational purposes today, and we're going to focus on providing some general information on the two new laws that were passed that are going to affect sick leave and paid leave. And if there are nuances unique to your situation, I'm certainly happy to discuss those with you, or one of the other attorneys in our office would be happy to do so. There's also a lot of information for us to cover today in those two new laws. So we probably won't have enough time to get to a lot of questions. But that being said, if you do have some general questions on the new laws, feel free to send us a chat message with those, and I'll try and handle them as we're able to. So hang on one second here if I can get to the slides. There we go. Thank you so much. Okay, so Cotney Construction Law, the firm that I'm working for now, is a full-service law firm serving the needs of the construction industry. We have employment lawyers. We have lawyers that can handle tax questions, immigration questions, contract, OSHA, you name it. Today we're going to focus on some of the employment aspects. And Bryce, I might need to get your help in changing through the slides here. Thank you. So this is the first time in over a century that the U.S. has had to face a pandemic. We have aggressive efforts that are ongoing to be made to stop the spread of the coronavirus. And these efforts are having some drastic impacts on our economy and our need to adapt, especially as these relate to employers and employees. So the World Health Organization declared a pandemic on March 11th of 2020, and the U.S. declared a national emergency 2 days later on March 13th. Many states, including our home state here in Colorado, have declared a state of emergency, and they're taking drastic measures to reduce the spread of the virus. We have school closures, closures of bars and restaurants, cancellation of trade shows and meetings, and I read this morning that the Olympics are also being postponed. And we have a number of jurisdictions now with shelter-in-place or stay-at-home rules, and I'll talk a little bit more about those in Colorado here in just a moment. We have other cities like Boston where they've been ordered to stop construction. That's especially hard for our industry. And we're still navigating a lot of questions on what essential business is for those areas where construction has not been ordered stopped altogether, but we're trying to navigate these changes together. Bryce, can you get to the next slide for me?
So January, I actually put you on admin status, so I think you should be able to.
Okay. Perfect. There we go. All right. Okay, so here in Colorado, we've seen a lot of rapid changes just in the last 48 hours. We had an executive order issued by Governor Polis on March 22nd that ordered Colorado employers to reduce in-person workforces by 50% in an effort to space people out and reduce the spread of the virus. We also have some exemptions in there for critical businesses and essential businesses. And in the press conference on that order, Governor Polis did indicate that construction is a critical business. A day later, we've had 2 stay-at-home orders issued by 2 more of our municipalities, Denver and Boulder. Denver's order has a little bit of a different definition of essential activities and the work that supports essential businesses. Therefore, it's really important for you to have someone take a look at those definitions for you, depending on where your workplace is. And also within the CDPHE order that was relied upon by Governor Polis. So consult an attorney or someone else, read those orders carefully to determine if the exemptions can apply to you. Our firm's also been working on letters for a lot of our clients to help them establish that they are an essential business and have those letters available for their workers and on job sites should someone come to ask questions about that. Okay. There are a number of legal issues that are arising out of this pandemic, and so I'm going to talk about some of those. Workplace mitigation and addressing employee concerns will be touched on. I'll also touch on a little bit of OSHA and safety for your workplace. Key contract provisions has been another one, but we had a separate presentation on this. It's so in-depth. We have a link in the slides to that, where you can consult for some information on specific contract provisions that may help you to enforce contracts during this difficult time, or where the need arises, try and get out of those contracts as well. I'm going to focus, though, in this presentation primarily on, as I said, the 2 new laws that are affecting sick leave and paid leave that were recently passed and that go into effect on April 2nd.
January, one quick question. Will we be able to make the slides available for everybody that's on?
Absolutely.
Great. So a few people have wanted to know your email and how they would ask questions. So we'll be able to get to that for everybody.
Sure. I'll provide the email at the end of the presentation, and then I'm happy to provide our phone numbers as well.
Great.
So this is some general information on workplace mitigation. It's really important for all of the employers out there to have good policies and procedures in place during this time. We don't want any of our clients certainly to have liability exposure that arises out of failure to implement those kinds of policies. So make sure that you have policies in place to mandate good hygiene with sanitizer and wipes. You mandate use of respiratory devices and personal protective equipment where it's necessary, given the type of work that you're doing and the crews that you have. Make sure that you're making exceptional efforts to sanitize common surfaces. Sick employees, this isn't like the usual situation where if someone's complaining of symptoms, that there's any question that arises, send them home. And provide notice to your other employees if you have someone that is experiencing symptoms or that is sent home and test positive ultimately for the virus. It's really important, and we'll get to that in a little bit in more detail, that you just disclose that generally to your employees. Provide them notice that there's been someone that has symptoms or that is tested positive, but don't identify the individual with specifics. Encourage your employees to call healthcare providers with any questions that they may have about the symptoms that they're experiencing. Some more general information about crisis management teams. It's going to be important for everybody, especially with the remote working challenges, to identify the key employees on their crew who can provide support during this pandemic. Develop remote systems for work. A lot of us were set up to work remotely on occasion, but it's brand new to be working remotely 100% of the time and having our entire staff do so as well. So make sure that you have policies and procedures in place so that you're able to communicate with your staff and control your workflow. Determine who is command in all posts and who is second to them. Develop and amend your HR policies to address workplace issues. It's an ongoing process. We have new news and information and new policies and recommendations on a daily basis. So have your HR department monitor those and make sure that you're updating your policies continually. Make sure that you have a plan in place for what happens if you can't access your office, and make sure that you have plans in place for communication failures, as well as checking in with your suppliers. We know there's going to be a lot of business interruptions. There's going to be a lot of delay in getting supplies. So make sure that you're able to communicate with all the folks in your supply chain and have a plan to address those concerns. We've had a lot of questions from clients lately on insurance coverage during this time. And so I'll just touch on these briefly. Health insurance, make sure your HR department is going to be prepared to field questions from employees on the health insurance benefits that are in place and the providers and networks that they have available to them. As far as business interruption insurance, a lot of questions recently on this as to whether it might apply to the situation that we're currently experiencing. Unfortunately, business interruption insurance typically carries a pandemic exclusion or a communicable disease exclusion. But make sure that you ask your broker or insurance agent to carefully review all your coverages with you. You might have a rider or some policy that would assist you in finding coverage, and your insurance agent is going to be the person who's most capable of guiding you through that. We've also had a lot of questions about workers' comp insurance and whether it provides coverage. That's a big maybe. And it would be very difficult here because the first prong of a work comp claim is that the employee is able to prove that their injury is attributable to exposure on the job site. Because of all of the unique aspects of coronavirus and how long it may be that the incubation period is in effect, or how long it might survive on surfaces, that's going to be a really difficult thing to prove. But that doesn't mean that it's impossible that we don't see these claims. In fact, I expect that we will start to see these types of claims, and we may see more of them in the healthcare industry. You also have to determine whether the claim would be covered by work comp. There may be policy exclusions. So again, important for us all to check in with our carriers and check in with our insurance agents on those questions. There are also a number of states that have applicable exclusions where work comp might not cover because of a specific statutory exclusion. I've heard that states like South Carolina may have some of those types of exclusions for pandemics. Here in Colorado, we don't have a statute that excludes pandemics from work comp coverage. However, as we've seen a lot of federal changes in the law that have happened rapidly, I expect that we'll also start to see some of those on a state basis. For example, Colorado has some special work comp sections to address medical workers' occupational exposures to hepatitis C and firefighters' occupational exposures to respiratory ailments. So it's possible that we could see state statutes start to amend quickly to carve out special exceptions. Disability and life insurance, all of the policies are going to be different in this area. So again, it's going to be necessary for you to consult your insurance agent or benefits administrator. Again, it's important to prepare your HR department to field questions from employees along these lines. Okay, now we're going to get into the meat of the presentation with respecting employment. There are a couple of different areas that we're going to touch on. So paid time off. There are existing laws that we need to interweave into this analysis. And there are the laws that are just been enacted that are going to impact how employers need to address requests for paid time off. So generally, before these laws were enacted, company policies determined how and when paid time off could be used. However, now with these new laws in place, if leave is being requested for a COVID-19 related reason, the new Sick Paid Leave Act will impact the analysis. And we may also have the FMLA extension that needs to come into consideration as well. And I'll talk about each of those in more detail in the next couple of slides. Turning to FMLA on the current slide, the Family Medical and Leave Act. This law has been in effect for a long period of time, and employers will still need to analyze its application as they always have, and now add on the new layers presented by the newly enacted extension, as well as how it might interplay with the Sick Paid Leave Act. So under the FMLA, if there is an eligible employee and a covered employer, it provides 12 weeks of unpaid job protected leave. And that means the same or equivalent job is held open or provided back to that employee at the end of those 12 weeks, and they retain their benefits intact during that leave if they have a qualifying event. So in order for the FMLA to apply, you need first to have an eligible employee, and that would be an employee who has been employed for the last 12 months with the company and who's worked at least 1,250 hours during that time. You need to have a covered employer. So the FMLA only applies to employers that have at least 50 employees within a 75-mile radius of the eligible employee submitting the leave request. The eligible employee needs to have a qualifying reason in order to be eligible for FMLA leave. And those include birth or adoption of a child, a serious health condition, or caring for a family member with a serious health condition. And that would apply equally to either parent in the situation of a child being adopted or born into the family. There is an exception to FMLA leave provided for key employees. And those are going to be your salaried employees that are at the top 10% of the salary for the employees within the 75-mile radius. And the company would have to show that it would suffer serious economic hardship by holding the position open for that key employee for 12 weeks' time. If you're dealing with a key employee, you can notify that key employee of that determination. And if they still decide to take the FMLA leave, you're not required to guarantee the same or equivalent position remain open for that 12-week time period. With the newly enacted laws, part of those are the Emergency Family Leave Extension Act, and it provides a lot of new layers to the FMLA, so we'll talk about those in detail in the next couple of slides. On this same slide, talking about wage and hour law. Under federal wage and hour laws, you only need to pay your hourly employees for the work they actually perform, but you're required to track their hours and required to pay overtime. For your salary exempt employees under the FLSA, if you reduce their salary or don't pay the salaried employees their full salary in a pay period, you risk losing exempt status, and that would cause you to have to then track their hours and pay overtime to that employee. However, if a salaried employee works 0 hours, this is in a situation where they work 2 hours or a half an hour, but work 0 hours in a pay period, there is a situation where you would not risk losing the exemption if their salary were reduced or unpaid during that time period. And talking generally still about wage and hour, it's really important for companies to update and revise their policies to address the shift to remote working. For your non-exempt folks, you need to find a means of tracking their hours and reporting those hours. It's really challenging where you're not able to supervise that work, but policies need to be put in place to ensure that you're complying with wage and hour laws. The violations for wage and hour can be quite severe. You can be facing liquidated damages, civil penalties, and attorney's fees. So you want to be really cautious about how you're handling and tracking your non-exempt employees and their hours. So moving on to the next slide, we're going to start to talk about the federal laws that have recently been put into place. So these new laws fall under an umbrella called the Families First Coronavirus Response Act. There are a lot of aspects of this act, but we're going to be talking about two in particular. The first is the Emergency Paid Sick Leave Act, and the second is the Emergency Family Medical Leave Expansion Act. They were enacted on March 18th, and they go into effect on April 2nd. It is going to be very, very important to get quickly up to speed on these laws and make sure that your HR departments are prepared to comply with what these acts require. And before we leave this slide, I just wanted to generally provide some information that the Act provides that employers, in exchange for these payments to their employees, are going to receive a quarterly tax credit that is equivalent to the payments made to the employees under these new laws. So now we're going to turn to the next slide on the Emergency Paid Sick Leave Act. This is an unprecedented law. We've never had a federal law in place that requires paid leave. So we're in brand new territory here, and it's going to be a lot of challenges to learn how to manage this and how to apply it. The law applies to all businesses with less than 500 employees. We are not yet sure if there's going to be an exception for small businesses. The way that the law was enacted by Congress, it leaves open the possibility for the Department of Labor to later make an exception for small businesses. And those would be businesses with fewer than 50 employees, where they could show that compliance with the law would jeopardize the viability of their business. However, we're still waiting on guidance from the Department of Labor as to whether they're going to implement that type of small business exemption. So for now, we can only state that it applies to all businesses with less than 500 employees. And you must provide paid leave if the employees cannot work or cannot telework for a number of specific reasons. So there are 6 that are set forth in the Act. So if you have an employee that after April 2nd comes to you to request this paid sick leave because 1, they are on quarantine or isolation order due to local or state laws, or they've been advised, number 2, by a healthcare professional to self-quarantine or to remain in quarantine, or 3, an employee who is experiencing symptoms and is seeking diagnosis, who's applying for leave during the time and during which they're seeking that diagnosis. 4, you have an employee who is caring for another who is quarantined or isolated or advised to do so. 5, you have an employee who has care of children because of childcare or schools closed due to coronavirus concerns. And then number 6 is kind of a catch-all. If you have an employee that's experiencing any conditions that are substantially similar to the ones set forth above. So again, important to remember that the employee has to be unable to either work or telework in order to qualify under one of those criteria. And if they do qualify and apply for leave, if they're a full-time employee, they'll get up to 80 hours of sick leave under this Act. If they're part-time, they get the average number of weekly hours they worked, averaged out over a 2-week period of time. The amount of the benefit that they'll get under the Sick Leave Act depends on the reason that they're asking for leave. So if we go back to the list of 6 reasons that are provided under the Act, if they fall under one of the first 3, and again, those are either quarantine or isolation order, advised by a health professional to self-quarantine, or someone that's experiencing symptoms and seeking diagnosis, if you fall into one of those 3 categories, the employee would be entitled to their full pay during that 80-hour time, capped at an amount of $511 per day. So for 80 hours or 10 days, you're looking at a maximum of $5,110. Again, it depends on the salary of the individual worker requesting that leave. If you're in the last 3 categories listed in the Act, so you're caring for someone else who's quarantined or isolated, if you have a child care closure and need to care for those children, if it's a catch-all, if you're experiencing any conditions that are substantially similar to the ones specifically set forth, then those employees under this act will qualify for 2/3 of their pay, capped at $200 a day, or a $2,000 maximum.
January,
Yes.
we did have one question that I think is pretty applicable here.
Okay.
So the question was, if I have an employee that is under government quarantine starting this Monday, so I think it was yesterday, does the Paid Sick Leave Act still cover, or is this law not in place yet? I heard you say April 2nd. When does this go into effect?
Correct. The laws don't go into effect until April 2nd. So that would be the earliest date on which you could have an employee apply for leave under one of these two new laws.
Okay.
So going back to the Sick Leave Act, you can't refuse to pay sick leave under the act if it's for one of the qualifying events. Really important that you also don't terminate, discipline, or discriminate against someone who is seeking paid leave under the act or who complains about a violation of the act. So you've got to be very cautious in how you handle those requests starting on April 2nd. Another important point to note is that you cannot force an employee to take accrued paid time off before they're entitled to take this new sick leave under the act. And they can keep storing up their PTO, and they can actually use it after they have completed the 80 hours to which they're entitled under the new Sick Leave Act. Again, the penalties for a violation of this act are very severe. So really important to have good information put through to your HR department on how to handle these requests coming April 2nd. The last part is we're still awaiting a poster from the Department of Labor that is supposed to be posted in a conspicuous place in the workplace. And yes, even if everybody's working remotely, they still mean the physical workplace. So we'll try and update folks as we know more about when the Department of Labor is going to have that poster ready, given that these new laws go into effect so quickly. So turning now to the Emergency Family Medical Leave Expansion Act. And actually back one slide if you could, Bryce, sorry.
Oh.
Perfect. Okay, so this one actually is an amendment and extension to existing law. It is an extension to the Family Medical Leave Act, FMLA, which we talked about a little bit earlier. It is solely related to leave requests for those who need to care for minor children who are out of child care or school due to the coronavirus concerns. And they have to be able to show that they're unable to work or telework because of the need to instead care for a minor child. Like FMLA, this extension will provide job-protected leave for 12 weeks. Unlike FMLA, it is paid leave. Your benefits remain intact, but you're also entitled to pay. And I'll break down a little bit about what type of pay each employee might be entitled to. Also important to note is that this extension of the FMLA is not subject to the same qualifiers that the pre-existing FMLA laws are. So you no longer have to have at least 50 employees within 75-mile radius, and you no longer have to have an employee that's been there full-time for a prior year. This new act applies to private employers with less than 500 employees and applies to all employees who've been with the company for at least 30 days. We're also waiting to find out if the Department of Labor is going to flesh out the same small business exception. So hopefully the Department of Labor will provide some further guidance on whether they're going to allow an exception for employers that have less than 50 employees who can show that compliance would jeopardize the business. Under this new act, the first 2 weeks of that 12-week period, or 10 business days, are unpaid. And the remaining leave of 10 weeks is paid at 2/3 the employee's rate at a cap of $200 a day. So if you're at that cap, the max for the 10 weeks of leave would be $10,000. There have been a lot of questions as to whether the employer can then inquire as to the circumstances for other childcare options, such as another spouse who's able to stay at home with the kids, or remote working and flex hours. And yes, those types of questions can be asked as necessary to determine whether the leave request falls within the Act. Return to work is handled the same as normal FMLA. You're generally required to give the same or equivalent position back to that employee when they return from leave. There's a small exception under FMLA for an employer with less than 25 employees, where you can show the position no longer exists. And then in that particular exception, you don't have to hold the position open for the employee. Questions about that before we turn to the next slide?
Yeah, one question, we're having a few of these. Does it have to be that they test positive for COVID-19, or do they have to be exemplifying the symptoms and get a note from a doctor? How does that work with some folks not being able to get tested?
Sure. So those questions would relate to the sick leave act, so the one that we covered on the previous slide. And if you have an employee that is experiencing symptoms and seeking diagnosis, that act expressly applies to that group of employees. So as of April 2nd, if you have employees that have not been able to get testing because of testing shortages or inability to access medical care due to the influx lately, those employees would be entitled to seek leave during the time when they're still seeking that diagnosis to confirm. So arguably someone who has symptoms and is able to show that they are making efforts to, but have not yet been able to obtain a diagnosis, would fall in that category.
So everybody, we're getting a lot of pretty specific questions. So I think the best way to do this, keep the questions coming, and we'll probably put this in an email that January, if you might be able to look at this afterwards, maybe we put this out and we'll blank everybody's names up, but we'll put those questions with whatever answer that January can put out there.
Okay. And in terms of people who are having symptoms, who are asking for leave, the extension to the FMLA is not going to be applicable. Again, that one's only applicable to a situation where you have a parent of a minor child who is unable to work or telework because of the need now to care for children who are at home due to school closures or childcare facility closures. So moving on to some of the potential HR issues, as we just touched on, your HR department is going to need to be carefully prepared to field and respond to leave requests. And you're going to need to have those procedures in place in order to address these requests starting on April 2nd. You're also going to still need to be prepared to address normal FMLA requests. You're going to have a lot of employees that are requesting leave for other reasons, and so you're going to have to determine under which act the request falls and respond appropriately. One other thing that if the situation should become worse that we might also need to take into consideration is the Worker Adjustment and Retraining Notification Act, or WARN. This applies to companies that have at least 100 employees who are full-time, by full-time meaning 20 or more hours per week. But also, that's just the federal aspect. There are a lot of states out there, I think at least 16, that have their own what are called mini WARN acts that expand the protections beyond just companies having at least 100 employees who are full-time. So really important also to check your state laws. I can at least tell you briefly that Colorado does not have a mini WARN act for those listening who are in Colorado. For WARN to apply, it has to involve what's known as a mass layoff. And mass layoff is gauged by an employment loss, and that would be a termination of more than 6 months in time, or a 50% reduction in the employee's hours for a period of time that's more than 6 months. It also has to be an employment loss that affects at least 500 employees at a single location within a 30-day time period, or an employment loss of at least 50 employees within 30 days at a single location where that reduction would be at least 33% of the employees at that location. So if you're in one of those criteria where WARN might apply, you're required to provide at least 60 days advance notice to the employees of the mass layoff that's coming. And you have to keep their pay and benefits intact during that notice window. Important to note that in calculating all of those numbers under WARN, that if an employee is unable to work because of COVID-19, they don't count toward the layoff numbers that you put into those calculations. There are also some exceptions under WARN that might apply in these circumstances. There's an exception under WARN for a natural disaster. Although COVID has not yet been declared a national disaster in the formal sense, that may be coming, and there may be arguments for that exception to apply. There's also a situation under WARN where a shortened notice period can be provided for unforeseeable business circumstances. And I think there are a lot of good arguments why that particular exception should apply to the current situation that we're facing. And if you have an unforeseeable business circumstance that's going to result in a mass layoff, you're still required to give as much notice as reasonably possible. There also is a bullet point on our slide about the Americans with Disabilities Act, the ADA. That law applies to companies with 15 or more employees, and you're not able to discriminate under the ADA against a disabled employee or applicant, and you have to provide them with reasonable accommodations. There's still a question mark as to whether COVID-19 is a qualifying disability, a brand new question. So it would have to be kind of analyzed on a case-by-case basis. Under the ADA, a reasonable accommodation could be remote working or providing leave to that employee. Also important to note that under the ADA, there's an undue hardship exception. You don't have to provide a reasonable accommodation to the employee if it would present an undue hardship to the business. There's a lot of case law on how undue hardship is defined, so it would be important to consult an attorney on your specific issue if this does arise. The ADA normally only allows for limited inquiries by an employer as to health information of the employee or applicant, but the EEOC has clarified that for circumstances such as a pandemic, that they were given a little bit more flexibility as an employer. The employers can conduct exams and screening where it's consistent with a business necessity, or if there's a reasonable belief that an employee might pose a direct threat to the health and safety of others. So with those guidelines in place, employers can screen for symptoms, and they can do those for employees that are still working on location. Obviously, it's going to be considered unduly intrusive if you're trying to screen for those types of symptoms for employees that are already remote working and they're not presenting a direct threat to the health and safety of others on your work site. You can take employee temperatures as they come onto the job site. You can ask employees questions about symptoms, about sick family members, about their travel. But always keep in mind when you're asking those questions of employees that you're ensuring they're directly related to your business needs or necessary in order to avoid a direct threat to the health and safety of themselves or others. You can also require that your employees have passed certain health examinations before they come back to work. So with COVID-19, if you have folks that have been home with symptoms or diagnosed, you can require that they have testing to ensure that they are clear of the virus before they return to work. Under the ADA, unlike some of the other laws we've touched on, the leave can be unpaid if you're going to provide leave as a reasonable accommodation. One other important thing to note, if you are doing some screening and questioning of your employees to try and determine if they pose a threat to other employees or the workplace, that the health information that you collect for those employees must be maintained as confidential to the greatest extent possible. It should only be transferred to those in the HR chain that need to know in order to make the necessary determinations. So as I mentioned earlier, if you have an employee in the workplace who has symptoms or who has tested positive, you do have a duty to tell your other employees, but you should not specifically identify the individual. So you can tell your employees, we have a worker who has tested positive or is experiencing symptoms, but don't tell them that it was John Smith. So if there are further questions on that, I'm happy to field those. Otherwise, we can move on to the next slide. Okay. So going back to some more general information on workplace messaging, in order to communicate with your employees about their safety, find means with remote working to discuss guidelines for their safety, to train and review all of these policies with your employees, to provide them with information on sick leave, pay, and benefits, and to provide them with information on OSHA and workplace safety as it relates to COVID-19. Okay, so we can go into the next slide. And I'm just going to touch on OSHA. So federal OSHA law, there's a lot of guidance that's provided in the link in these slides. Again, I'm happy to provide the slides to anyone who might like to have them. One of the important things under federal OSHA law is a general duty clause. And that is that the employer has an obligation and a duty to provide a workplace that is free of recognized hazards. So here we're talking about a duty to provide necessary sanitation to ensure good hygiene, to provide protective gear where it is necessary and essential to accomplishing the job, to make sure that you are sending folks home that have symptoms and minimizing all risk that you can, that other employees might be exposed, and that you're taking proper precautions to comply with recommendations of local government and the CDC and our local health department here in Colorado as well. There's also some information here on personal protective equipment. There's probably a lot of controversy about that. I know that when our office in Tampa did this presentation, I think there was some discussion about N95 masks. So I think really decide for yourself if those masks are necessary and essential to the jobs that you're performing. If they're not, maybe as just a personal recommendation from me, consider whether you might want to donate those instead to our medical professionals. And if there are further OSHA questions that you have, we have a number of attorneys in our firm who specialize just in this area alone, and they'd be happy to help answer your questions and provide some further information on how to ensure job site safety with respect to COVID-19. Okay, moving on to the next slide. So these are just some common sense safety tips that you can have regular employee meetings or toolbox talks about COVID-19 to make sure that you are reinforcing continually to your employees proper hygiene and protection. Also, a good idea to have some documentation in place if you can have a sign-off sheet for these types of meetings. The more that you can provide documentations of policies and procedures and compliance with those, the better off you're going to be. We certainly don't want clients to have liability exposure later with folks arguing that they did not have policies and procedures in place to protect them, to warn them, to provide them guidance on these issues. Workplace, if you have folks that are still coming into work, and we hope that we're all able to do that, you need to make sure you're sterilizing common working surfaces, including the equipment. If you have job trailers and trucks and tools, make sure that you're trying to minimize the spacing between, or I'm sorry, maximize the spacing between people, maintaining that 6-foot distance wherever possible. You need to provide job site protection plans where you can. Again, documentation here is going to be the best thing that you can do. We have some that we've been putting together for clients that you can have employees take out onto site and provide some recommendations as to appropriate measures to take on site to stop the spread of coronavirus. Make sure that you're training your superintendents and crew leaders on signs of the illness and pull sick workers out immediately. Make sure that they're not remaining on site and you're really carefully monitoring for symptoms and checking in with your your employees. Okay, then next slide. Job site safety. These are some general pointers for the construction industry. Restrict job site trailer access. I think we're fortunate that right now we're in spring weather, and so hopefully we can get those meetings outside and maintain the 6-foot distance between folks on site. Do as many job site meetings as you can in a virtual manner. If anyone on the job site appears ill, make sure they're sent home immediately. Make sure that if you need personal protective equipment on site, that you're providing it in an appropriate manner. Don't recycle it, don't pass it out to folks and then take it back and not ensure that it's disposed of appropriately. For water, if you usually have shared water containers, consider bottled water as an approach, or asking employees to bring their own individual water containers to job sites. Daily reporting, try and do that virtually whenever you can. Use text, photos, or any other program that you can on site. And for meetings over 10 people, be cognizant of the local and state laws that are in place where that's been restricted. We have a lot of virtual meeting options that are open to us now. I've heard a lot of great things about successes people are having with Zoom. In-person safety training, discontinue that to the extent that you can. You still need to be conducting all of your safety training. Find a way to go virtual with it and have everybody involved in that manner instead. Make best efforts you can to sanitize and clean the work site and all common surfaces on an ongoing basis. So as part of our efforts to keep our clients apprised of all these developments, we are developing a packet of information for our clients that will have information in it, including a job site protection plan, preparedness and response plan, certificates that you can use to show that employees have complied with training on COVID-19, sign-up sheets and check-in sheets for toolbox talks on those topics, and also all of the information that I covered on the 2 new federal laws on leave that is set forth in an employment guide and resource for our clients. And we have a fixed price for that packet of information. And it's also free for certain members of our firm's subscription plan, including all new subscription clients. We're also working on letters for clients to indicate that they are an essential business. There have been some question marks with the conflict in recent orders and how that's been defined in each of them as to whether each company would be considered to fall within an essential business exception. So we're working with clients to analyze their individual situations and provide those letters to them so that they can have them for their employees and on job sites in case questions should arise. We're also happy to field any questions that folks may have about their individual employment concerns, contract concerns, or OSHA concerns during these challenging times. Bryce, I'm not able to hear you. I don't know if your mic is on.
Yep.
Okay, perfect.
Had to take the mute off. So we've had a few questions on in here. I think some of these are pretty detailed. And so I think if we can kind of take a look at this afterwards, we can email out, because I've got everybody's emails, email this out to everybody. And if they have certain specific questions, they can reach out to you specifically. We'll see if there's any other, let's see here. And Jason Gillis has been very, very active on the chat here. Yes, I did just turn on the lights with waving my hand. This is in January. Did you have the Amazon guy at knocking on the door in the background, or?
Oh, quite a few times. They were really persistent about the doorbell and knocking on the door. It might have been my kids. I'm not sure. So
your focus was really on point. So just bring a little levity into this. Working from home, wherever everybody's at, is kind of going to be a new normal for a little bit. So. Really appreciate you taking your time for this. Let's see here. We have one other question here. So Susan asked, would the packet include the exempt letter needed for the crews to travel, work in, stay in place, ordered areas? I think that's kind of going to be up to you guys. Does that come with it?
The packet right now doesn't include the specific letter for whether somebody falls within an essential business exception. We're working on that on an individual basis for each company because the circumstances are so unique. The packet is more generalized information that we think will apply across the board for our clients. But the essential services letter or essential business letter, I think we're doing those at a very low rate. I'll have to double check exactly what it is, but it's been a minimal charge for that. We're using templates that we have in place that have the orders from Denver, from Boulder, from Governor Polis, so that we're able to tailor them appropriately after we understand what the client's specific business is and where they're operating.
Okay. And for everybody on here, so we just had a couple of late people join us. We will be sending out the PowerPoint with everything here, so you can catch up on that. And then we will also be putting this entire presentation up on our YouTube channel, so you can watch it through again, or please share it with anybody that needs that. I think on the exempt letter, Tradecraft is actually going to be getting one of those, and so we might be able to put kind of an example together for everybody to just see if that's something that you'd like to have for your businesses, and then you can reach directly out to January or Cotney Construction Law for that individually. So
I did forget one thing. Speaking of, so my email address is not on the slides, but it's a fairly easy one, I hope. So I'll rattle that off quickly, and if anybody needs that, I'll give the phone numbers out as well for the office. So the office line should be forwarded to us, even though we're working remotely. My email address is my first initial J, my last name Allen, ALLEN, at cotneycl.com. So altogether, it'sjallen at cotneycl.com. And our main office line for Denver is 303-653-9155. And then I think our general information email address is on the back slide in this slide deck.
And we'll also put that when we send out a thank you letter to everybody, thank you email to everybody, so we can put Cotney Construction Law contact information on that too.
Perfect.
Awesome.
Well, thank you, everybody. Bryce, thank you to you and Tradecraft again.
Thank you very much. And everybody, we've got a few more webinars coming up. Tomorrow, we've got one on the SBA emergency loans. And then on Friday, we're going to be doing a comprehensive social media branding marketing meeting with some pretty high power marketing folks about how companies can be looking to pivot because this is kind of changing everything with remote working, and really how companies are forward facing out into either B2B or B2C. So definitely don't miss either of those. So thanks everybody. Thanks January.
Thank you.